Duke's Andrew Willinger on how Trump may change the DOJ's approach to gun litigation. That and more on this episode of the Weekly Reload Podcast.
No, the devil's got no hold on me.
All right, welcome, ladies and gentlemen, to another episode of the Weekly Reload Podcast. I'm your host, Stephen Gutowski. I'm also a CNN contributor and the founder of thereload.com, where you can head over and sign up for our free newsletter today if you want to keep up to date with what's going on with guns in America from a sober, serious perspective that focuses on hard news reporting and analysis over, hot air and opinion, basically. Of course, if you want to help support the independent and informed reporting we do here at The Reload, you can always buy a membership at thereload.com. That is how we fund what we do. This week, though, we also have an ad swap with the Dispatch. I'll tell you a little bit more about them. Very similar style publication to what we do, but I'll give you a little more information on them at the end of the show. We are going to talk once again, actually, about Donald Trump and his administration's approach to guns this second time around, and some of the potential implications from the executive order that he handed down just a few weeks ago here. This week, though, we are going to get a different perspective from last week's episode with Independence Institute's Dave Kopel. Instead, this time we have Andrew Willinger from the Duke Firearms Law Center. Back on the show. He's been on before, but we're having him back on, get a little bit of a different perspective on things from you. Andrew, welcome back to the show. Appreciate you coming on.
Thanks so much for having me, Stephen.
Can you tell people just a little bit more about yourself and the Duke Firearms Law Center for anyone who is not informed on that?
Absolutely. So I'm the executive director of the Center for Firearms Law, which was the first academic center at a law school that focused on the Second Amendment and gun regulation. We aim to grow the scholarly field of firearms law within the academy. And we also have a number of resources, including a blog and a database of historical gun laws that are available on our website, firearmslaw.duke.edu. And I've been in this position for almost 3 years now. I was formerly a commercial litigator, but I've been thinking, writing, teaching about firearms law for the past 2.5 years. And I think actually I came on last time right after Bruin was decided, and that was my first day in the job when the day that Bruin came down. So
big day,
a busy start.
Yes, for sure. I think you guys are putting together that historical gun law database kind of in anticipation of something like Bruin, because it seemed like that's where the courts were headed at the federal level, at least. And yeah, I think it's you guys bring a very different perspective, I would say, from Independence Institute and Dave Kopel, which is why I think it's valuable to have you on and to go through some of these things. Speaking of the blog, you wrote a piece about Trump's executive order. It's a little more focused than what we did last week. It's more zeroed in on the Department of Justice and how they might change their approach to some of these gun cases in the running through the federal courts as a result of the executive order. And, first off, I guess we can start with kind of the ones everyone's been focused on. Some of the big ticket items, I will say, like the assault weapons ban, litigation, or magazine restrictions, or carry restrictions, those sorts of things that have filled up the dockets and sort of lifted the hopes of gun rights activists in the wake of Bruin. Those really don't have a lot to do with the federal government, right? They're mainly state cases against states. They happen in the federal courts, but they're not cases against the federal government or federal laws. So most of what we've seen in terms of federal litigation against the federal government, where the DOJ is going to be tasked with defending federal laws, gun laws, have to do with rules that the ATF implemented under former President Joe Biden. And so let's start with there. But there's also, of course, age restrictions on handgun sales from federally licensed dealers is another area. But let's start with the rules. Where do you see right now? There's already one at the Supreme Court, right? Vanderstock is a case we're waiting for a ruling on from the Supreme Court. They already had oral arguments in this case last year in October under the Biden DOJ. What do you think is potentially going to happen there? That's the so-called ghost gun case, right? The regulations on unfinished firearm frames and receivers that the ATF implemented during the Biden administration. How do you think the Trump DOJ is going to react to that case?
Yeah, so I mean, I think first off, this sort of clearly comes within the language of the executive order directing the Attorney General to basically reevaluate litigation positions in any case that may impact the exercise of Second Amendment rights. It's not a Second Amendment case, so it's maybe a little further afield from some others, but I think that language is sort of broad enough to capture some of these major administrative law challenges that you've mentioned, and Vanderstock, of course, top of mind because it's already been argued, and we're sort of in the posture of waiting for a decision that presumably would come in the regular course by the end of the term in June.
It's the most immediate case, for sure.
Exactly, yeah. And I think also just as a way of sort of as kind of an introductory note, I think most court watchers, based on how the oral argument went in the case, think that again, if things are allowed to sort of play out, that the court would uphold this regulation. So in contrast to what the court did with the bump stock ban, that they would find this to be a permissible exercise of agency authority.
Yeah, the court seems interested in kind of deciding for themselves what they think the statutes mean, and then siding with the ATF or against it based on that. It feels like that's where they're going in both of those cases. But by the tenor of oral arguments, seems like they'll probably side with the ATF on this one if it reaches that point, right? But that's the question.
Exactly. And so, and that's the question. So, we have presumably a few months before, could be an earlier decision, but a few months before we might expect it to come down. And the question is whether the Trump DOJ will try to, indicate in some way to the court that it is considering or intends to repeal this rule, get rid of this rule. There really isn't, in my understanding, there isn't sort of any sort of formalized process by which this would happen. It's just something where the government could submit a letter of some kind indicating what it plans to do, and then it would be up to the justices whether to decide to put the case on pause or something while that played out. I'll note that we have seen the Trump DOJ submit similar filings in other high-profile cases. They submitted one in the transgender medical treatment case, Tennessee's ban on certain treatments for transgender minors, and basically said that they had, and that's an instance where it's the federal government versus Tennessee is how the case essentially is styled, and the DOJ said, we've looked at this again. We wouldn't have intervened to challenge this lower court ruling, which upheld the law, if we were to sort of do things anew today. And we think that essentially that Tennessee should win and this law should be upheld, but we're not going to drop out of the case because it would create difficult issues and might sort of moot the case, and there's nobody that would be able to take our place. And I think that's just sort of because there's an expectation that the court is going to rule in that case that Tennessee's ban is constitutional, which is the result that the administration would prefer. So they're kind of content to let that play out. Now you might think in Vanderstock that the opposite is true, and so they might be much more motivated if, as I said, it's correct that the court is poised to uphold the ghost gun rule. Then presumably the administration might be more motivated to try to stop that type of decision from coming down, again by making a filing with the court. We haven't seen that yet, and in some sense the clock is ticking. And I think, as I talked about a little bit in the post, I'm not totally sure it's right that the administration, in an ideal world, would would basically do away with the case and moot it.
We don't know exactly what Donald Trump or Pam Bondi, the Attorney General, actually thinks about this policy, right? These regulations on unfinished firearms and receivers. We don't. I'm not aware of, at least, Trump speaking out against that. Other than just he has broadly spoken out against anything that Joe Biden did on gun policy, and this being one of those things. But I don't know that, especially somebody like Pam Bondi, who has supported a number of gun restrictions when she was Florida's Attorney General, and not necessarily ghost gun restrictions or unfinished frames and receivers restrictions, more red flag laws and age restrictions. But it's not clear that they actually oppose what the ATF did in this case. I guess that's the wrinkle, right, that you're alluding to here. They might not want to stop the Supreme Court ruling, and I guess like you said, that Tennessee case is perhaps an example of what they could do. It's a little bit different because the federal government's the plaintiff in that case, and the Trump administration might want to lose the case, and people seem to think the DOJ is going to lose that case, or at least that's the what people are reading of tea leaves. But and in this case, the DOJ is in a position to maybe win, but if I don't know, they're not moving as quickly, right? And this is a common theme that you've seen in the early administration here when it comes to gun priorities. They're not moving as fast on this stuff as they are on a lot of other things, and we just don't know exactly where they'll come down. And you think perhaps they won't side with gun rights activists in this particular instance?
Yeah, I think that's right. I mean, certainly in the category of reading tea leaves, but I think it seems like maybe where the administration would prefer to be here is in a situation where the Supreme Court issues its decision, upholds the rule, and then they sort of deal with this after the fact on the side of sort of setting enforcement priorities and basically saying, we don't really intend to go out there and aggressively prosecute people under this ghost gun rule, but there are high profile instances of criminals using self-manufactured or self-built firearms, and so it's important for public safety reasons to have this type of rule on the books. And I think in that situation, the Supreme Court ruling maybe provides a little bit of cover for that, if that's ultimately where the administration wants to go.
Yeah, because obviously the other priority that they have to balance any sort of gun rights thoughts against is this sort of law and order approach that they that Trump likes to talk about. He's he has talked about taking guns first and having due process second. Obviously, it was fairly infamous comments he made in his first term. More recently, he's talked about letting police. He supported stop and frisk policies in the past and even during the 2024 campaign. So, there are some areas where there may be tension between, gun rights priorities and sort of law and order type priorities. But I guess COPA was fairly skeptical that they could actually do this in the time that's left to have an effect in this case. But I think you seem a little more of the mind that they absolutely could if they wanted to.
Yeah, and I think it's a subtle difference, but I think I'm totally. I have no reason to question. I listened to your conversation with Dave, and I have no reason to question what he said about sort of the actual timeline, amount of time it would take for them to get this regulation off the books. What the administration certainly could do is indicate to the Supreme Court if that's the path that was going down, right? And I think they probably would do that if they had made that decision. They would inform the court. Then it would be up to the justices again how to handle it. But I think
they certainly still could do this. I mean, the PO gives DOJ 30 days. We're not at that 30-day period yet. We don't know exactly what the Department of Justice is going to do. A lot of this is just speculation based on past actions. But it does remind me a bit of the pre-Bruin case that made it to the Supreme Court and then was mooted before they could rule on it against New York City and their firearms transportation restrictions. But that was mooted because the city actually and the state went out of their way to pass legislation and put it into place during the period after the Supreme Court accepted the case. And so the Supreme Court agreed to moot that case because there had already been the changes made to invalidate it, right? Whereas here, I guess you'd have to rely on them accepting a letter that says we're going to reverse this.
I think that's an important difference, and I also think that on the margins, the fact that the federal government is obviously a repeat litigant before the Supreme Court, and the justices, they recognize, I'm sure, that reversals happen, that the new administrations come in and take different positions. Right. But they're, if that happens one too many times, you could imagine some frustration. And so there may be a calculus as well that, they're going to only do this in cases where they really find it, there's sort of like a complete determination. We obviously need to reverse this position because it's untenable.
And so what about the other rules? They obviously they've all fared pretty poorly in court so far. These Biden-era ATF rules, the pistol brace rule, the one about used gun sales requiring federal licenses, or some changes to try and force more people to get a license to sell used guns. And I guess the export controls that were put in place last year as well. Although that I don't think has been litigated and may not be subject to quite the same Second Amendment arguments that the other ones are. Because, we're talking about exporting firearms instead of, which may not implicate the Second Amendment in the same way. But we've seen action in one of those cases, right? Already?
Yeah, that's right. So we've seen action in one of the circuit cases, I believe, where there was a request for a continuance, which is kind of the same idea, the type of letter I was referencing earlier, but I think carries a lot more weight before a circuit court, where if the government comes in and says there's a pretty good chance we're going to change our position here, can we have some time to dot the I's and cross the T's on that? The judges are going to give them that time, generally speaking.
And that was the pistol brace rule, I believe. And
I think that's right. Yes.
I think they asked for that because oral arguments were supposed to be at the beginning of next month. And so they're kind of like, hey, we got this executive order from the president. He wants us to review all these cases. We need some time to do that. Please give us some time. That's basically what they did, right?
Yes, that's right. And I should say, I guess a couple of things, just kind of reacting to some of what you said earlier. The first is that I think one of the things that struck me, and I haven't really written about this, but looking back over the executive order, is the sort of like almost going back and forth between referring to Second Amendment rights, referring to infringement of the Second Amendment, and then referring more broadly to gun rights, to rights that might impact the exercise of the Second Amendment. And it's just a sort of, to put a finer point on it, these are not Second Amendment cases. There are, in some instances, atmospheric arguments, maybe sort of constitutional avoidance type of claims about the Second Amendment, but they're squarely administrative law cases. And
that is a fair point, right? Yeah, I mentioned they implicate the Second Amendment, but really these cases are not Second Amendment claims; they're administrative law claims. Most of them are based on the Administrative Procedures Act, right? That's essentially saying that the ATF has exceeded its authority to do these kind of regulations because it's over interpreting federal law, and they're not really using Second Amendment arguments in most of these cases, at least not as the primary claim.
Yeah. And then on the point about the pistol brace case, I do think it's a little bit interesting that you have, maybe this is just a timing issue, but you have that request to continue the oral argument there. The government did argue and defend before a circuit court the federal ban on handgun sales by FFLs to 18 to 20-year-olds in the Fourth Circuit. And that was after the administration had turned over. So again, maybe that there just wasn't enough time for them to formulate a change there. But it doesn't take a whole lot of work to ask the court to say, hey, can you push this argument date back a little bit? And they didn't do that in the Fourth Circuit case.
And was that before the executive order came down? I guess.
I think that was the week before. Yeah.
So maybe maybe that part of it they just hadn't received the request to review these cases yet, and they said just kind of move forward with how things had been. I don't know, or maybe they're not going to change course on that in that area. That would be a surprising one because that is a Second Amendment claim.
That's a Second Amendment claim, and I think that'll be a really interesting one to watch because we have the Fifth Circuit's decision in Reese striking down that set of statutes. And then the Fourth Circuit case where having listened to the argument there, I would be very surprised if they reach the same outcome. So I think they're going to uphold the law, at least at the panel level. This goes to a point that you talked about a little bit with Dave, which is it's easier in some sense to sort of change position by just deciding not to appeal when you lose, rather than sort of coming into court and saying, "Oh no, we now have all these different arguments." This is sort of the opposite of what we told you before. So you could see in the Reese case, maybe the government just decides not to seek cert there. It'll be interesting. I think they have 90 days from whenever that was issued. But then they'll still have to deal with this Fourth Circuit case where it may not be up to them whether it goes up to the Supreme Court. Yeah,
I mean that's another really key point to get at is sort of the litigation strategy involved from us in these Second Amendment cases, because that's something where you can have a pretty significant impact on just how you choose to litigate things. Just the timing of stuff. I mean, the post-Bruen, the Biden administration did a pretty masterful job of in how they sought to get certain cases in front of the Supreme Court, ones that they thought were going to come out the way that they liked, and that's how we got Rahimi, right? The DOJ, they prioritized getting Rahimi in front of the Supreme Court over something like range, right, which is on the opposite end of the spectrum as far as post-Bruen cases go, where it seems very likely that the Supreme Court would probably side with the plaintiff in range, but the plaintiff or the defendant in Rahimi was much less sympathetic, and the circumstances were much more favorable to getting what the Biden DOJ wanted in that case, and so they maneuvered how they chose to appeal those cases. They did eventually try to get the range in some of these other cases in front of the court to no avail. But, they wanted to prioritize range, and they did, Rahimi, and they did, and they got the outcome that they wanted from that, even under a very strict new test for Second Amendment cases, right? And so you could see certainly the DOJ under Trump, if they're smart about how they litigate these Second Amendment cases, they're going to have the ability perhaps to get the cases they think are most favorable to them in front of the court before later cases that they maybe don't think are as favorable, right? I mean, I think that's perhaps an overlooked part of all of this. That's, people focus a lot on, oh, well, maybe they'll stop defending, federal law that I don't like, or maybe they'll change their position in this gun rights case. Perhaps more important than any of that is just how they move to get certain cases to the Supreme Court in certain order, right?
Yeah, I think that's a really good point. I have some quibbles with the Rahimi observation, just because I think that the Fifth Circuit easily could have decided we need to send this case back to the district court for historical fact finding, right? Which would have been a very defensible position. They chose not to do that and issued this decision right away. So it was kind of first in line. But I think your broader point is absolutely correct, which is that the DOJ has a lot of ability to steer things and to get things up to the court that it wants to go up to the court. So whether that's range, whether that's if maybe they want the age case to go up and then be able to say, well, okay, we think the Supreme Court's going to strike down this provision of the Gun Control Act, and we're okay with that. So we're gonna force their hand. That's a possibility too.
Yeah, but speaking of federal cases and sort of the more overlooked ones, we obviously spend a lot of time discussing the high profile cases. Assault weapons ban case, the age restrictions, concealed carry restrictions, these ATF rules, stuff like that. But the bread and butter of federal gun prosecutions are felon in possession infractions, right? This is what the vast majority of actual cases are. And that's another area that's potentially interesting under a Trump DOJ, right?
Yeah, that's right. So as you mentioned, this is by far the most frequently utilized subsection of 922G, these person-based prohibitors in federal law. And the way I see this potentially playing out is sort of a maybe a subtle shift in how these cases are argued, which is that I think we're starting to see the emergence of a view that you kind of a court should look at different categories of underlying felonies and then also do some kind of examination of the criminal history of a defendant and try to figure out whether there's any indication of dangerousness. Now, as some of the circuits to adopt that view have applied it, I think it's actually not a huge practical shift, because they're essentially saying that even nonviolent offenses are qualifying and it's constitutional to apply the felon ban to them if there's a risk of violent confrontation. And that would include things like drug offenses, for example, which I was trying to find some numbers before this. I couldn't find the statistics, but I have to imagine that many defendants who are charged under the felon in possession ban have underlying convictions for drug offenses. So that's a big one. And so that's the view that's sort of starting to take shape. And I think I could imagine the Trump DOJ kind of embracing that position in some of these cases. Now, how they get there is sort of an open question, but you have cases like range, where presumably they will want to either get a ruling from the Supreme Court that application of the ban to somebody with this type of pure nonviolent offense and upstanding history of being a good citizen, that's unconstitutional.
Because Range's offense was food stamp fraud,
lying on an application for food
for
stamp
like
fraud.
$2,000 of food stamps or something.
Yeah, I think it was
which
actually
he never
his wife.
served actual jail time for. It was just that he had the potential to serve jail time that qualifies him.
Exactly.
There's a similar case of a homeless woman, I think, writing a bad check for like $500. There's a couple of cases like that out there that these people still end up under the lifetime ban. But what's interesting there is, to me, is if you go back to Rahimi, right, and the Biden DOJ's arguments in that case centered around the idea of less of dangerousness, although they kind of got knocked it down toward closer to dangerousness by the Supreme Court in oral arguments. But they started off with this idea of like, irresponsibility. Right. If you're irresponsible, if you've broken laws that Congress has created, that shows that you're not a responsible, citizen, as is some of the terms the Supreme Court themselves had used in Heller and Bruin. And that was their position. You didn't have to have like a violent history. You just had to be sort of a irresponsible person, as evidenced by your convictions of these crimes, these certain more serious crimes that the Congress has deemed felonies. And the court didn't like that very much. And that's where I'm guessing you see Trump DOJ could go from a much stricter idea of dangerous behavior being what's needed for lifetime prohibition.
I think a stricter idea. I don't know if I would say much stricter, because again, I think the view that the Trump DOJ is likely to embrace is one where, as sort of these courts have started to hold, things like any drug offense would qualify, right? Even if it's an inherently nonviolent offense, but again, it creates the risk of a violent confrontation. And the reason I say that is because I think that, again, we talked a little bit about the law and order focus and some of the focus on illegal drug trafficking. I think when when there are instances where drug, enforcement of drug-related prohibitions and cracking down on drug trafficking might conflict with gun rights, I think the drug policies are going to prevail. Those are frankly just more important. And so, I wouldn't expect the Trump DOJ to take any sort of drastic steps to argue whether it's in a 922G1 case or a case in the unlawful user prohibition, right? I don't really see them changing things drastically in those areas.
Yeah, definitely a friction point, especially given that they were very much in favor of the prosecution of Hunter Biden for his gun crimes, which stem from him being a drug user and not any sort of violent crimes that he committed. He wasn't accused of any violent crimes during the course of his prosecution. They were financial crimes, tax evasion, things like that, and being a drug user and buying a gun, lying on the background check that he wasn't a drug user, that sort of thing. And they were, there wasn't outrage from the Trump campaign around his prosecution. So yeah, you would think perhaps, and obviously Trump is very, one of the key priorities he has is going after, drug dealers and drug trafficking. That's always been a top talking point of his. And so, yeah, there's definitely friction there, because presumably a lot of the felon in possession, nonviolent felon in possession cases probably do stem from some sort of drug crime being the initial prohibitor. Although, it is interesting to think through this too, just with Donald Trump's own background, right? I mean, he is a prohibited person. He's a convicted felon. His crime is a nonviolent crime. Obviously, it's another sort of financial crime, campaign finance related crime, not reporting, campaign expenditure essentially is what he was convicted of, and not a drug crime, but maybe that's where there's something closer.
I think his
type of crime,
falsifying business records that would qualify too. I think again as a sort of offense with the level of punishment that meets the definition.
Right. He was convicted of he spent this money to help advance his campaign by covering up the affair with the porn star, but he reported it as something else in his books. That's what he's convicted of. Yeah. And so obviously not a violent crime nor a drug crime. Right. And maybe that influences how DOJ is going to approach cases like range or some of these other nonviolent crimes that aren't drug related. I don't know. What do you think?
I think it's definitely possible, and I think those are probably the most likely ones where we'll see a full scale reversal of the government not saying this is a categorical prohibition that is okay in all of its applications, right? And instead saying there are certain areas where the felon ban cannot be appropriately applied when you have a purely nonviolent offense. And again, I think they have, I guess, maybe like a sort of a menu of options of how to get there. They could try to take to our earlier discussion. They could try to take a case up, and actually that might be the quickest way for them to sort of settle the area if they're pretty confident that the current Supreme Court would side with somebody like Range. They could not appeal, right? The Third Circuit found in Range's favor, right? So maybe they just just choose not to take the case up. And more broadly, they could just argue these cases differently and sort of take a softer position than the Biden DOJ did.
Is that common for DOJ to take a case where they're hoping to lose, like to pursue a case where they hope they lose? Is that a? I mean, I
don't think it's common. I'd probably put that. Yeah, no, it's probably pretty low on the
like strategically. I understand it, right?
Yeah.
But is it really something that DOJ does? I can't think of an example of it.
Yeah, I'm not sure either.
Certainly possible. I just Usually though, like I can think of them. I mean, very rare, and Copel made this, was pretty adamant about this, that refusing to defend a law is something that's very rare and unlikely, though not impossible. It has happened, including the Trump administration. The previous Trump administrations refused to defend federal laws on very rare occasions. So,
I guess the better. The more, or maybe the much more likely option there would be a case like Vincent, where you have the circuit court saying we can't entertain any as applied challenges. You have a purely nonviolent felony, no subsequent misconduct, and then that would be the case to take up, presumably.
Yeah, because DOJ can come out and say, well, we don't see a viable path to defending this law under, the Second Amendment, or under how the courts are interpreting the Second Amendment. That sort of thing, I guess, is the way that would be a rare but not unheard of approach. But yeah, ultimately, I guess you're still of the mind that that it's likely we'll see significant changes in the approach of the DOJ to gun cases, whether they're Second Amendment cases or administrative law cases, as a result of, maybe not as a result of this executive order, but just as a result of a new administration coming in, right?
Yes, I think that's true, and then especially in some of the areas we've talked about. I do, again, want to emphasize, though, that I think when there are these conflicts between gun rights and other policy priorities that just, the evidence clearly suggests are more important to Trump and to the Trump administration, we're going to see gun rights be sort of secondary, right? And I think another area to highlight there is immigration, where you do see some of these. You have cases under 922 G5, which bans illegal immigrants and some other immigrants from having guns, and so you see some interesting opinions in those cases by conservative judges who are quite pro-gun, quite expansive in their view of the Second Amendment, but not in those contexts. And I think that's an indication kind of what might happen when those two considerations collide. Yeah,
that does seem to be the path that they're on right now. It's not necessarily, obviously the Biden administration was actively hostile to the interests of the gun rights movement, and was an ally for gun control movement, or however you want to label each. But we're not going to see that from the Trump administration, certainly. But it does appear that the priorities list has gun rights pretty far down. It's not that it isn't on there, or that there won't be changes that gun rights activists like from this administration. It's just that, like you said, at least so far, when we've seen them conflict with other interests that Trump and the administration seem to value more, they lose out. I mean, we just, on the news update this week, we talked about the export license ban or pause, freeze, which is probably not targeted at the gun exporters like the Biden one was from last year, but it's actually more expansive and hurts them probably more the longer it drags on, because it affects more firearms exported to more countries. So, and that seems to be born out of this priority to rearrange our trade policy. And so that takes precedent over what, any sort of short-term harm done to gun exporters or what have you. So, yeah, I mean, that's the view. I think that's been borne out so far. Maybe it'll change down the line, but yeah, I think that's a fair observation to this point. All right, well, look, I appreciate you coming on and giving your point of view and giving us a little bit of different perspective from what we got last week. If people want to follow more of your writing and the work that you do over at Duke, where can they do that?
Yeah, absolutely. So most of what I write is published on the center's blog, Second Thoughts, which is available through our website, firearmslaw.duke.edu. And I am also occasionally on Twitter or X and Blue Sky. So my name is not very common. It should be easy to find me if you're interested.
All right, wonderful. Well, appreciate you joining us, and we'll have to have you back on again in the future. I'm going to hand it off to myself to tell everyone a little bit more about the dispatch and our little ad swap that we have going on. All right, folks, it's time to talk a little bit about the dispatch, doing an ad swap here between the reload and the dispatch. And I think that's fitting because if you like what you're getting from the reload in terms of high quality reporting that focuses on hard news, you'll probably like the dispatch as well, because get this, they also focus on high quality reporting and hard news. Now, they are a much broader publication than the Reload. We obviously focus on one specific area, whereas the Dispatch has a much larger team and is able to focus on a whole number of other issues, but still primarily in that national politics realm like we do here at the Reload. But they are one of my favorite publications. I am a paying member to the Dispatch. And so clearly, I highly recommend it. I've been a paying member since they were founded, and I've never had reason to rethink that even once. So they are constantly breaking news stories. They are sending you newsletters on whatever frequency you want. They have quite a variety of them over there. But I subscribe, for instance, to the Morning Dispatch, and I get, I think, a very nice summary of what's really going on from a pretty sober perspective. That newsletter is hard news, and it's focused on it, and I think it's fantastic. But they also, of course, have some of the best commentators, in my personal opinion, over there as well. It was an outlet founded by Steve Hayes and Jonah Goldberg, two guys I've known for a long time. They've been on the Reloads podcast. Kevin Williamson as well has been on our podcast. So you've heard from these guys if you've been a Reload listener for a while here. And, I think you should check out the Dispatch if you haven't already. We have a free trial as well, 30-day free trial for Reload listeners if you want to go over and check out their paid offering, which I think is well worth the money. So I'd encourage you to do that. There's a link in the description of this podcast or on our website if you want to check it out. So head over to the Reload to get that link, or head over to the Dispatch to see what they're all about.